Thank you for joining us today. Welcome to our second webinar in our three-part webinar series on international arbitration. Over the next hour, Natalie and I are going to discuss arbitration best practice as it relates to preparation for arbitration, funding of arbitration, and securing payment of an award. We will not be taking live questions during the webinar, but we look forward to receiving your questions and feedback after the session. I want to start by reiterating that arbitration remains the most common form of dispute resolution in the construction industry, and we anticipate there will be an increase in the number of arbitrations in the next few years, particularly in the wake of the unusual COVID-19 crisis. The market is struggling, as we are all aware. Work has slowed down. Clients have approached us seeking advice on suspending projects. We have also had a number of queries on force majeure provisions and the ability or inability to fulfill contractual obligations as a result of the pandemic. We are also seeing an increase in pre-COVID-19 claims being brought forward now. The decrease in the number of new projects coming onto the market means that there are fewer opportunities to recover losses on bad projects, and parties are becoming less inclined to protect relationships. Although there may be an increase in contractual disputes, we also see a reluctance to commence new cases immediately, which, given the circumstances, is not surprising. In times of economic and financial strain like these, companies are focused primarily on their ability to continue operating as a going concern and seek to turn to dispute resolution at a later date. However, it may in fact be more prudent for companies to consider the arbitration options sooner rather than later, especially given the commitment of arbitration institutions to operate as normal during these times. Moreover, the almost inevitable influx of cases in the medium term as a result of events during the outbreak makes it advisable to commence a case as soon as the necessary facts have been established. Natalie will also discuss and take you through options that are available to parties, such as third-party funding, to finance their claims. Now, given the time and cost involved in an arbitration, you'll probably ask yourself if it's worth preparing for arbitration. The simple answer is yes. As we will discuss, preparing your claims as though you are going into arbitration will gear you into looking at the strength of your claims and addressing any weak claims. Whether or not you eventually do proceed to arbitration, the preparation will put you in good stead for negotiations. Today, we're going to address a number of points which we hope make the arbitration process worthwhile for those taking part in it. And these are steps which are geared at ensuring that at the end of the arbitration, you have an award that you can enforce, which results in the payment of the amount you have been awarded. Most of what we are addressing today is directed towards those who are the claimant in arbitration proceedings. We will touch on issues which concern respondents as well, but the focus will be on the position of the claimant. So we first turn to a number of key steps in preparing either your claims or yourself as claimant in arbitration proceedings. The first question you should ask yourself before commencing arbitration is, are your claims in order? It sounds a rather basic statement to make, but you need to make sure that if you are commencing arbitration, you are commencing them in respect of disputed issues which you know have merit and have gone through any preconditions to arbitration which you have agreed to under the terms of your contract. As to the first point on disputed issues that have merit, as most of you are familiar, the claims that often arise in construction projects are technical and revolve around delay, disruption, defective works, or dispute as to what the bill of quantities allow in terms of payment. As the claimant, you should get your claims reviewed by either experts or consultants before committing your claims to arbitration and committing yourself to the cost of those proceedings. In fact, we are seeing a number of our clients now are getting claims consultants or independent experts on board with a view to commencing arbitration proceedings in the near future. As to the second point on satisfying any preconditions, let us consider this example to understand what may be a precondition to commencing your arbitration. So Contractor A is appointed to construct a hotel in the UAE. The construction contract adopts the FIDIC Red Book 1999 Conditions of Contract. Contractor A has claims for extension of time and additional payment that it now wants to refer to arbitration. Are there any preconditions it should complete before filing an arbitration? Assuming the general conditions of the FIDIC Red Book are not amended, before Contractor A can commence arbitration, it should first refer the dispute to the Dispute Adjudication Board that is to be appointed in accordance with the contract. The Dispute Adjudication Board is to give its decision within 84 days of a referral of a dispute. If Contractor A is not satisfied with the decision, it should issue a notice of dissatisfaction within 28 days of the decision. It is important to issue this notice, which is clearly a precondition to arbitration. The wording at subclause 20.4 of the FIDIC Red Book is quite clear when it says, neither party shall be entitled to commence arbitration of a dispute unless a notice of dissatisfaction has been given in accordance with this subclause. Following the issuance of the notice of dissatisfaction, the parties are to engage in amicable settlement before referring the matter to arbitration. We sometimes see the dispute process in the FIDIC Red Book is amended in the particular conditions, for example, to refer disputes to a dispute committee instead of adjudication. Similar to the adjudication process, the contractor should accordingly refer the dispute to the dispute committee before commencing arbitration. It is important for a claimant to ensure that all preconditions to commencing an arbitration are satisfied to avoid its claims being decided as inadmissible because it did not follow the proper contractual procedure. The importance of satisfying such preconditions was confirmed by the Dubai court in a commercial case in 2016. The contract in question was based on the FIDIC suite of contracts and referred disputes to an engineer before arbitration. The referral to an engineer was seen by the court as a precondition to arbitration that had to be satisfied, failing which the claim could not be referred to arbitration. A referral to an engineer is similar to referral to the Dispute Adjudication Board or Dispute Committee in that it's a precondition. Contractors should also be mindful that just because they referred a particular extension of time claim to the engineer does not mean that you can refer any later claim for an extension of time to arbitration, which relies on grounds different to that which was considered by the engineer. The key point to remember is to follow the dispute process set out in the contract to the letter to avoid such issues. The second point you need to consider, and it is linked to the first point, is have you complied with notice provisions within your contract? We're all very familiar with notice provisions, particularly under the FIDIC forms of contract. The standard provision in the FIDIC Red Book requires the contractor, where it considers himself to be entitled to any extension of time or additional payment, to give notice to the engineer as soon as practicable and not later than 28 days after the contractor became aware of the situation or circumstance giving rise to the claim. If the contractor fails to issue such a notice, it risks any entitlement to additional payment. With the COVID-19 situation, contractors and subcontractors will likely face shortages or delays in supply of labor or materials, and the cost of obtaining these resources may increase. Where such situations arise, it is paramount for the contractor or subcontractor to issue the relevant notices to preserve its entitlement. For example, let us assume as a contractor, one of your laborers on site has been diagnosed with COVID-19 and the UAE government has ordered the indefinite quarantine of the labor camp in which your entire labor force is housed. This is the only labor camp in the UAE subject to such a limitation. Assuming the FIDIC Red Book applies, what notices should the contractor consider issuing? At this stage, the contractor does not know for sure that its claims will go to arbitration. However, preparation from the outset is key. Therefore, as part of preparing any claims that may arise out of this scenario, the contractor should carefully consider issuing the relevant notices under the FIDIC Red Book. For example, subclause 8.3 requires the contractor to promptly give notice to the engineer of specific probable future events or circumstances which may adversely affect the work, increase the contract price, or delay the execution of the works. This would be such an event. As the first course of action, the contractor should notify the engineer of the UAE authorities' quarantine of the labor camp at the soonest and assess the impact, if any, it will have on the construction program. The FIDIC standard conditions do not penalize the contractor for failing to give such notice under subclause 8.3. However, to avoid the employer raising this point later, especially if the issue proceeds to arbitration, it is advisable for the contractor to give such notice. Further, Article 246 of the UAE Civil Code requires parties to act in good faith in their dealing. This is an implied obligation that requires parties to deal honestly and fairly in their transaction. The contractor's failure to issue such a notice, which would in effect better prepare the employer for possible delay to the completion date, would likely be seen as the contractor's failure to act in good faith. Following a notice under subclause 8.3, the contractor should also consider notices to raise any extension of time or additional cost claims. The contractor could consider possible extension of time claims under subclause 8.4d on unforeseeable shortage of personnel, or subclause 8.5 delays from authorities. Where the contractor considers it is entitled to raise a claim, it should do so within 28 days in accordance with subclause 20.1. In the UAE, there's a general understanding that either judges or arbitrators are reluctant to reject a claim purely because notice requirements have not been complied with. Are you familiar with the saying, "A good claim never dies"? It is often bandied about here as a catch-all to any failure to give proper notice in respect of claims. We would advise against relying too heavily on this concept. We recently successfully argued that failure to provide notice precludes a contractor from making a claim, and the arbitral tribunal agreed with us. In this particular case, the employer had reminded the contractor of its notice obligations on several occasions, and the arbitral tribunal took this into consideration. The claims in question were of around 80 million dirhams, so quite a substantial amount. The arbitrator found, in this case, but for the contractor's failure to give notice, he would have been entitled to an extension of the time for completion and relief from liquidated damages, and presumably prolongation costs, although they had not been claimed in the arbitration. Therefore, consult with your lawyers and get in your notices on time. Particularly now is not the time to lax. Consider the best approach and provisions to rely on for your claims, if any, arising out of the COVID-19 pandemic, and put them in. Okay, so you've checked off the first 2 points. That is, firstly, you know that your claims have gone through any preconditions, such that an entitlement to refer a claim to arbitration has arisen. And secondly, you know that your claims are not going to fail because of a failure to give timely notice. The third issue we want you to consider is what assets are there available to enforce your award against, and can you attach against them? Arbitration is a costly and lengthy process, and there may be little merit in going through this process unless you get the relief you are seeking at the end of it. And for a large majority of cases, this, of course, is payment of money. The assets do not have to be located in the country where the arbitration takes place or the respondent's home country. The Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the New York Convention, was adopted by a United Nations Diplomatic Conference on 10 June 1958 and entered into force on 7 June 1959. The Convention requires courts of contracting states to recognize and enforce arbitration awards made in other contracting states. Widely considered the foundational instrument for international arbitration, it applies to arbitrations that are not considered as domestic awards in the state where recognition and enforcement is sought. The process allows you to apply to have your award recognized in any of the courts of the contracting states, that is, the countries that have signed up to the New York Convention. 163 countries have signed up to it to date, including most in the Middle East. The most recent contracting states to join the convention this year was Seychelles, who signed up in February, and Palau signed up in March. It is important to consider whether or not you can enforce your award and to get advice on this. This is especially because the national laws of countries may have different approaches to enforcement. For example, there was a flurry in the arbitration community when in 2016, the Dubai Court of Appeal, in the case of Fluor and Petrixo Oil and Gas, refused to enforce the foreign award on the basis that no evidence had been submitted to establish that the UK had signed and ratified the New York Convention, and that such evidence was required to show that the UK courts would reciprocate in respect of the enforcement of awards issued in the UAE. The decision surprised practitioners as the UK signed up to the convention in 1975. The Dubai Court of Appeal judgment was appealed to the Court of Cassation, which overturned the judgment and recognized and enforced the London ICC award because both the UK and UAE are signatories to the convention. Finally, consider whether there are assets which are related to the claims you're advancing and which you may be able to attach against at the outset of the arbitration proceedings in order to secure any award against the assets should the award be successful. Under UAE law, there are a number of provisions under the UAE Civil Code that allow for the attachment of assets, where a claimant can show that it has a credible claim against a defendant and has a legitimate fear that the defendant is dissipating or may dissipate its assets to frustrate any judgment awarded to the claimant. The court's power to issue a precautionary attachment order in these circumstances is found at Articles 252 to 256 of the Civil Procedure Law. Other jurisdictions have similar provisions. Section 44 of the English Arbitration Act 1996 allows a party to apply to the court for interim relief in order to preserve property rights which are the subject of a dispute in arbitration. However, the court may grant an order only if the arbitrators are not themselves empowered to act. Arbitrators are generally empowered by the rules that govern the arbitration proceedings. For example, Article 28 of the ICC rules provides that the arbitral tribunal may, at the request of a party, order any interim or conservatory measure it deems appropriate. The arbitral tribunal may make the granting of any such measure subject to appropriate security being furnished by the requesting party. Let us now look at preparation of arbitration from the respondent's perspective. As a respondent, you would want to start by considering whether or not the arbitral tribunal has jurisdiction to hear these claims. So the first question to ask yourself, is there a valid arbitration agreement in place? What constitutes a valid arbitration agreement depends on the seat of your arbitration. For example, in the UAE, where the seat of arbitration is Dubai, according to the UAE Federal Arbitration Law, an arbitration agreement must be in writing. The arbitration agreement could be part of a document signed by the parties or contained in an exchange of correspondence, which can include an exchange by way of email. The Federal Arbitration Law allows for incorporation of the arbitration agreement by reference to any other document containing an arbitration clause. This will constitute an agreement to arbitrate, provided that reference is clear both in its meaning and in stating that it forms part of the agreement. A key objection often raised in relation to the arbitration agreement is that the party signing it did not have the relevant capacity to do so. The Federal Arbitration Law provides that when the arbitration agreement relates to a company, it can only be concluded by an authorized representative who has authority to arbitrate. This is important because one of the grounds for challenging an arbitral award set out in the Federal Arbitration Law is that the party to the arbitration does not have the legal capacity to enter into the arbitration. For a UAE LLC, this would usually mean being either the general manager or a person having the authority to act on behalf of the general manager. There has been a long debate as to whether this authority should be express or apparent authority should suffice. In 2014, the Dubai Court of Cassation recognized apparent authority of a person signing an arbitration agreement on behalf of a company where the company is named as a contracting party in the agreement and the individual signing the agreement did so in their capacity as representative of the company. The Federal Arbitration Law does not appear to contradict this point. However, the extent to which this argument is plausible will depend on the facts of the case. It is always advisable to avoid such issues and to have clear power of attorneys and authorizations in place. The second point to consider as a respondent is there an entitlement to commence arbitration of the claims being referred? This goes back to my earlier point when we were looking at preparing for arbitration from the claimant's lens. Before commencing an arbitration, the claimant should ensure that it satisfies any preconditions to the arbitration to ensure that its dispute is ripe for arbitration. As the respondent wishing to challenge the arbitral tribunal's jurisdiction, you should comb the dispute resolution provision in the contract to check if the claimant has followed the required steps before commencing the arbitration. Tied to this point, the respondent should also check if the claimant has put in valid notices in accordance with relevant notice provisions. Lastly, a respondent should be aware of any waiver provisions. For example, Article 34 of the DIAC rules provide a party which knows that any provision of or requirement under these rules or other rules applicable to the proceedings or any direction given by the tribunal has not been complied with and yet proceeds with the arbitration without promptly raising an objection to such non-compliance shall be deemed to have irrevocably waived its right to object. Therefore, a respondent should raise any objections in a timely manner to avoid waiving its right to do so. As a respondent, you may wish to bring counterclaims. Similar to the claimant, you too should consider what preconditions are there in respect of counterclaims. Is the counterclaim closely linked with the claims being advanced such that the counterclaim must be considered in determining entitlement? If the counterclaim is not in any way connected to the claims, is a separate referral to the engineer required? As discussed earlier, this is important to consider to avoid the claimant arguing that your counterclaim has not been properly referred to arbitration. A respondent may also consider an application for security for costs. Security for costs is an interim protective measure available during an arbitration. It is obtained where a respondent is concerned that the claimant may not have enough money to pay an adverse costs order. Such an order is available under most arbitral rules, but in practice, they can be difficult to obtain in international arbitration. A respondent seeking security for costs should consider the relevant institutional rules and if an arbitral tribunal is authorized to grant such a measure. For example, Article 25.2 of the LCIA arbitration rules expressly authorize an arbitral tribunal to grant security for costs. In contrast, the ICC rules do not make express provision of this power. However, it is widely recognized and accepted that they fall within the ambit of the general power awarded to tribunals to order conservatory or interim measures. Closer to home, the position of security for costs in the UAE was clarified in the UAE arbitration law. Although the arbitration law does not contain specific wording, unlike, for example, the English Arbitration Act, which clearly provides the tribunal may order a claimant to provide security for the costs of arbitration, it does provide the tribunal with wide powers to order interim measures. A party seeking an order for security for costs could arguably request for such measure under the tribunal's broad powers. Institutional rules such as the DIAC rules also appear to empower the tribunal to issue orders for security for the claim or counterclaim. I'll now hand over to Natalie, who will take you through third-party funding.
Thank you, Sadaff. As I'm sure you are all aware, the construction industry is rife with litigation due to lengthy design and construction timelines, complex projects, increasing government regulation, and challenging financial environments. Parties can often find themselves exposed to multiple disputes at any one time. Over the last few years, there's been a significant increase in the percentage of construction companies based in the UAE involved in contractual disputes. In addition to the increase in the number of disputes arising on construction projects, it was also recently reported that the average time spent resolving construction disputes has reached a 9-year high of 20 months, with many of the larger and more complex disputes taking even longer to resolve. And as Sadaff mentioned earlier, over the next few years, we expect to see the number of disputes arising in respective construction projects to continue to increase due to the impacts of the COVID-19 crisis. Delays caused by disruption to work on site, material supply disruptions due to closed factories and shipping delays, along with investment plans for commercial and residential building works being halted, if not cancelled outright, are no doubt going to lead to an increased number of disputes. However, historically, when the economy dips or experiences a sudden shock, companies do tend to bide their time before commencing legal proceedings. Litigation and arbitration cost money, and claimants often have to wait until business recovers and they have sufficient funds to hire lawyers and pay court or arbitration fees. Cost recovery is not a solution to the problem because, if available, that occurs at the end of proceedings, regardless of when costs are in fact incurred. As a result, even companies with strong claims sometimes wait even right up until the end of a limitation period before launching legal action, in the hope that by that stage cash flow problems will have eased. Unfortunately, this has certain undesirable consequences, the most obvious of which is that companies do not obtain legal redress at the time they need it most. Another problem is that witnesses' memories fade over time, and their evidence becomes stale and unconvincing, potentially undermining the claimant's case. It is also inherently risky to leave legal proceedings to the last minute in case there is an argument about how long a limitation period runs, or a limitation deadline is inadvertently missed. This is where third-party funding, also known as litigation funding, comes in, and it is something that companies should be aware of if they are to maximise their chance of obtaining compensation for legal wrongs, and doing so quickly, at a time when cash flow is critical and compensation is urgently needed. So, what is litigation funding? Litigation funding is where an unconnected third party provides finance to cover the expenses of bringing, or in some instances, defending a claim. Funding is provided in exchange for a return tied to the outcome of the case, such as a portion of the settlement received, or a portion of the judgment or award received from the court or tribunal. The core concept of litigation funding is that it is a form of non-recourse finance. This means that the financier's investment return is contingent upon success. If the case is lost, the litigation funder does not receive any return. The lender will have no recourse against the borrower for any of the finance that it provided to fund the claim or defence. Litigation funding usually covers a party's legal costs and disbursements. This will include legal fees, court or arbitration centre costs, as well as any experts and arbitrators' fees. Relieving some of the financial stresses of a litigation should allow the lawyers, the experts, and the client to focus on the merits of the dispute from an early stage and therefore increase the chances of a successful outcome. It should also be emphasised that litigation funders do not control the management of the case. Although the funder is financing the litigation, decisions regarding the litigation and potential settlement remain primarily in the hands of the client and its lawyers. So how does litigation funding work? A party can approach a litigation funder with a proposal for litigation funding. This will usually be prepared by the party's lawyers and sets out the claim, analysis of the merits of the claim, and the prospects of enforcing any award in the future. There are a substantial range of factors that a litigation funder will take into consideration when assessing a party's proposal. Litigation funders will also often have their own experienced lawyers in-house who will assess the proposal. The first factor funders will look at is the prospect of success of the claim. The higher the prospects of success, the smaller a percentage of the value of the claim the litigation funder is likely to seek in return for providing the funding. Another important factor that the funder will look at is the prospects of enforcing the claim. A very wide variety of factors will be looked at here, but to give an example, the funder will look at whether the counterparty to the claim has significant assets which can be enforced against. This will mean counterparties who are often much larger, such as multinationals and companies which have assets such as machinery, plants, buildings in the jurisdiction, and where there is less of a risk that these assets would be dissipated. The forum in which the claim is to be brought will also be important. For example, court proceedings in the UAE are unlikely to be particularly attractive if the counterparty's assets are mainly based outside of the UAE. Conversely, arbitration proceedings in England might be less attractive where the counterparty's assets are in Saudi. Funders often have relatively high demands when it comes to the percentage of the award or judgment it will receive if the party as funded is successful. Typically, a funder will seek a share of the recovery in the range of 15 to 50%, depending on the costs and risks involved in the funding dispute. A more useful figure is perhaps the damages to cost ratio of 4 to 1, which is often requested by litigation funders. This figure means that a litigation funder will aim to seek a 400% return on any investment. By way of example, if a funder provides 2 million dirhams worth of funding, it would want to claim back 8 million dirhams from the damages. This relatively high figure is due to the inherent risk of litigation and the fact that the projected funding may increase or the amount of any judgment or award may be less than originally thought. Third-party funding can also, in some instances, be available to respondents seeking to defend a claim. However, in reality, funding solutions for defence cases only makes commercial sense where the funder can be paid from some monetary event arising from the success. Such situations include an agreement to give the funder a stake in a future asset or income flowing from the successful defence, for example, if the claim is over the disputed ownership of an asset. where the respondent has a counterclaim that is larger than the claim they are defending, the logic being that the funder's success fee can be taken from the damages awarded in the counterclaim, or where the business has a portfolio of litigation matters supported by the same funders. This enables the funder to offset any unrecovered legal costs incurred when unsuccessfully defending a claim against the success fees recovered in other cases where the same business is making recoveries as the claimant. A party can seek litigation funding at any stage of the arbitration. However, approaching a funder at the earliest possible stage in the dispute will be beneficial for all parties. For example, a failure by a party to provide adequate resources to its lawyers early on in a dispute may prevent its lawyers from taking all necessary steps to secure relevant evidence and engage counsel and experts of choice. And this may be a determining factor in a funder rejecting an application for funding, notwithstanding the fact that the case had a good chance of success. So, what are the benefits of litigation funding? The main benefit of litigation funding is that it mitigates some of the risk of bringing or defending a claim, as essentially a third party, the litigation funder, assumes some of that risk on your behalf. It is obviously helpful where a party lacks the financial resources to pursue a claim. It also levels the playing field where smaller businesses operating in the construction sector face disputes against much larger and well-capitalized organizations. Having access to those same resources enables smaller businesses to engage lawyers and experts for the full duration of the dispute, which will invariably assist in obtaining either a more favorable award or settlement. Litigation funding is, however, equally suitable in situations where a party has the resources to pay the cost of bringing or defending a claim. By seeking external funding, a company can protect its cash flow and ensure that its financial resources are not diverted away from the day-to-day operations of their business towards often costly and lengthy proceedings. It is also beneficial from an accounting perspective. Through litigation funding, the costs of the litigation are moved off the balance sheet and onto a third party. Accordingly, litigation funding can improve the balance sheet of a company. It should, however, be noted that some provision will have to be made for the litigation funder's percentage of the receivable if there is a success in the litigation. There are, however, a number of disadvantages in respect of litigation funding. Obtaining funding can be a lengthy process. The due diligence that a funder carries out takes a considerable amount of time, especially if a claim is complex or a number of the claims are being considered. In addition, the detailed terms of the funding arrangement have to be negotiated. These are not just standard clauses. Many have to be drafted carefully to reflect the nature of the claims, the claimant's particular circumstances, and most importantly, each participant's appetite for risk. Additionally, substantial costs can be incurred when initially packaging the case for presentation to a funder. These will be wasted if the application for funding is unsuccessful. A successful claimant will generally have to pay a significant proportion of his or her recoveries to the funder. Although funders are generally restricted from taking undue control of the matter, there may be some loss of autonomy on the part of the funded party, in particular when considering settlement, as funders may reserve the right of approval of the settlement. So let's now look at some legal and practical considerations. The first thing to be aware of is that you may be subject to disclosure obligations to tell the counterparty that you have litigation funding. For example, the DIFC recently introduced a new practice direction on third-party funding in respect of claims in the DIFC courts. This practice direction requires a party which has a litigation funding to put every other party relevant to the dispute on notice of the fact that it has entered into a litigation funding arrangement. This requires disclosure of the funder's identity, but does not require disclosure of a copy of the litigation funding arrangement unless the court orders otherwise. Being required to disclose this fact is not necessarily a bad thing. Indeed, If your counterparty in the litigation knows that you have litigation funding, this will often indicate to them that a party has reviewed the claim and consider it has been worth financially supporting. Parties to an arbitration in which the governing law is UAE law are currently free from such obligations. Another consideration is that when seeking litigation funding, it's very important to get potential litigation funders to sign a confidentiality and non-disclosure agreement. Documents provided by a client to its lawyers are considered privileged under UAE law and are therefore considered confidential communications that do not have to be disclosed to a third party or the tribunal or court. But if the lawyers or the parties share these documents with a litigation funder, privilege may be waived. Litigation funding has developed considerably in recent years, and in particular since the financial crisis of 2008. The types of funding available to organisations operating in the construction industry has become more flexible and suitable for a wider range of cases. Until a few years ago, funding was generally available for single claims only. This meant, in effect, that it was offered only to claimants with a strong case and where any judgment or award obtained could be easily enforced against the defendant. In addition, claims had to be relatively large to attract funding, to ensure that there was a reasonable recovery to cover the funder's costs, return, and the client's damages. This all meant that funding was available in only a narrow range of cases, and arguably ones that would have settled quickly anyway. However, funding is much broader in scope now, allowing smaller claims to be supported as well as larger ones. This has been made possible by the evolution of portfolio funding, whereby a funder backs not just one big claim, but a number of claims of varying strength and value. Here, the funder looks not at the prospects and size of any single claim, but at the strength and value of all the cases combined. Because risk is spread across different legal proceedings, there is less chance of a legal upset, and of the funder losing the entirety of its investment. So a more broad brush approach is appropriate. This development is therefore particularly helpful to construction firms who usually have multiple claims on their books. This portfolio or book of cases could include claims you are bringing or defending, local, international claims or arbitration disputes, as well as those claims where, if seen on their own, are too risky to be considered for litigation funding. Through grouping the claims together, the funder's interest or risk is spread and cross-collateralized across the entire book or portfolio. This evolution not only widens the potential scope of litigation funding, it has also led to a change of mindset for many potential claimants. Whereas claims would often be neglected in the past, filed under too difficult or too expensive, until legally impossible to pursue, now they can be presented to a funder who will review the merits from a neutral point of view, itself a valuable exercise. The funder then makes an offer, if appropriate, to fund those claims that it finds commercially attractive. While financing disputes that are pre-judgment or pre-award remains the cornerstone of litigation finance, both on a single case and portfolio basis, financing can also address the problems faced after the successful resolution of a case. For example, if settlements are subject to court approval or other claim administrative processes, legal fees and awards can be delayed for years. Understandably, this can cause frustration for organisations who will have better use and more immediate needs for their capital. Equally, where a judgment or award has been obtained but the counterparty refused to pay, litigation funding can be used to assist in asset tracing and enforcing against the debtor. Litigation finance is therefore essentially a tool to optimise cash flow at every stage. Until recently, use of litigation funding was largely confined to jurisdictions such as the UK, Australia, the US, Singapore, and Hong Kong. This is largely due to the fact that litigation funders had a tendency to gravitate towards jurisdictions that are well established, predictable, consistent, and transparent. In addition, Where the funding relates to an arbitration, third-party funders like jurisdictions in which an arbitral award is enforceable. However, within the last few years, litigation funding is now increasingly being used in disputes related to the Middle East. The UAE has not always been an obvious destination for third-party funders. This was in part due to historical reasons, including the lack of legal certainty given the absence of binding precedent and perceived transparency in the local courts, the court's approach to the enforcement of arbitral awards, and the general lack of regulation of third-party funding. More recently, however, the UAE has seen a number of promising legal developments, including the enactment of the long-awaited standalone UAE arbitration law and the implementation of the DIFC practice direction that I mentioned earlier, as well as the ADGM regulations relating to third-party funding. These regulations are helpful because they give clarity to the status of funding, provide direction on disclosure to alleviate concerns for conflicts of interest, and provide an opportunity for the larger community to familiarise and gain access to litigation funding. So in conclusion, given the number of disputes in the construction industry is on the rise, the average time taken to resolve disputes is increasing, the lack of liquidity in the market, particularly in light of the current COVID-19 crisis, and the increased availability of litigation funding, it is likely that litigation funding will play a more prominent role in the UAE construction market in the coming years and could help a significant number of businesses get through these difficult times.
Before we close, let us briefly look at arbitration award default insurance. The clue is in the title. It is obtaining insurance against the risk that an arbitral award will not be honored. Arbitration award default insurance is often obtained where you have a sovereign state as the respondent. There is often an actual payment risk following an international arbitration against a state respondent. Arbitrations can take years to conclude, and the state's political or economic situation can change dramatically during that time. The benefit of procuring such an insurance is that it removes the risk of non or late payment following a successful international arbitration, specifically against a sovereign state. It negates the need for claimants to pursue lengthy and expensive enforcement proceedings. The policy can be purchased at any time during the arbitration proceedings, but is not available once an award has been made. Please do bear this in mind. We see a lot of arbitrations out here where the respondent is a sovereign state, and we have had success in obtaining and implementing a policy which provided arbitration award default insurance. Obtaining such an insurance policy is different from funders who specialize in the enforcement process in return for a share of the recovery. That is another matter entirely. The key takeaways for you today are: be alert to your claims, prepare early, get your notices in, and be mindful of any preconditions to arbitration. There are benefits to third-party funding, especially now more than before. Third-party funding can be highly beneficial in taking your claims forward without weighing down too much on your cash flow. Thank you for joining us. We look forward to receiving your comments and questions on this webinar. Do join us for our final webinar in this three-part international arbitration webinar series, where we will explore the UAE arbitration law and how it has fared in the 2 years since its coming into force. On a final note, we provide a virtual in-house service to our clients where you have access to any member of the project's team. Please feel free to get in touch with us. Thank you.